I extend a very warm welcome to all for this 131st webinar on proposed SEBI regulation on prohibition of unexplained suspicious trading activities in the securities market and consultation paper on mandating additional disclosure from FPIs. Friends, as you are aware, the name itself signifies that SEBI is bringing out the new law, and where they want to prohibit the unexplained suspicious trading activities in the security market. So the word unexplained suspicious trading activities itself is a indicative that SEBI wants to stop this type of transaction. If you read the SEBI consultative paper, then you will realize that SEBI has given various examples, and they have discussed this, that this type of cases which they have identified, they know that this is a suspicious, but because of the reason of the Indian legal system and certain things like new technology, new novel ideas created by the traders, then concealment of the transactions, identity of the person is not clear and it is different. Then web of trading, that buying from 1, 2, 3, 4 and so many people. So SEBI has recently issued this consulted paper, and on 18th May 2023, and their focus was this USTA. This is a new term which is unexplained suspicious trading activities. We have PIT, we have FUTP. Now this is a new word, USTA, unexplained suspicious trading activities. And the aim was to deter and deal with unexplained suspicious trading activities in and around the presence of material non-public information. Now this is also new word they have given in the definition, material non-public information. And the proposed framework, they want to address evasive tactics like multiple different dummy accounts, complex structures, encrypted communication used by potential suspected entities. And friends, in this new regulation, SEBI has brought out various new terminology like generally available information, influencer, like so many people recently we have seen in pump and dump case that the word influencer has come, material non-public information. Earlier we have unpublished price sensitive information. Now they are specifically coming out the material non-public information. Then suspicious trading activities, that is also new word they have coined. Then unusual trading pattern. This is also new definition they have brought out. Then unexplained suspicious trading activities. So three new words they have they have given a definition: suspicious trading activities, unusual trading pattern, unexplained suspicious trading activities, and they have given the definition which we will discuss today in detail. So friends, the purpose of SEBI is that they are very specifically mentioning that law is there. But if you see the law of income tax, if you see the other law, and they're strictly implementing the evidence law, then all these culprits or all these suspect people are not coming under the law, because when it is going for judicially scrutiny under the Evidence Act, they are finding very difficult to prove. SEBI has given a very interesting analysis also, and they have mentioned in 2022, 5,000 alerts came, which was out of this 5,000 alerts, 3,588 was a unique clients, well, unique people were there, and 97% appeared more than 5 times and more than 5. And then they mentioned this, that out of this 60% not proceeded because non-availability of evidence. So 97% trading, which is more than 5 and more than 5 or more than 5, they apprehended that this is a repetitive, suspected, and But out of this, 60% out of this 97, they have not proceeded because there was no evidence available. And 40% where they have identified the UPSI and different uh, evidence points was not available, and it was very difficult to prove in the court. You can just do certain things, identify that this is a suspect person, but until unless you are going to the court with the complete proof, you will not find that this is the transaction. Then they have mentioned this another data that every day there are 1.5 or 2 crore trades are taking place. And in this, because SEBI is talking about not only few things, they are talking about the insider trading, they are talking about the front running cases, they are talking about the manipulative, fraudulent, pump and dump, front running, various types of cases are there. So in the front running, they are saying out of 1.5 or 2 crore trade per day, it is very difficult to identify which are the front trading. So SEBI came out with the new idea that they have brought out to curb this type of practices, the new law. Now the question is, the new law, they have prescribed the new definition, they have prescribed that what are the transactions will come into this category. Then they have prescribed the investigation process, as well as they have given the exemption also, that if you are coming into this category, then you have to be exempted if you can prove that this is not repetitive, you have not done on the basis of some information, and this information which you have done, it has converted into loss, and various defense mechanisms they have given. But the most important thing in the Evidence Act, which is a little bit different, in the law it is prescribed that if I'm charging you, you have to prove that the person who is charging, he has to prove that where you have done the wrong thing. But here the SEBI is saying, I will charge, and you have to prove that you are not guilty. This is one area, gray area, which has a repercussion and which we want to discuss today, threadbare, on this issue. So this is unexplained suspicious trading activities law, which has come. Now, second consultative paper, SEBI came out on May 31st. It pertained to foreign portfolio investors, that is FPI, mandating more disclosure from high-risk foreign portfolio investors that have concentrated single group exposure or significant overall holding in their Indian equity investment portfolio. The new disclosure are to guard against possible circumvent of minimum public shareholding, that is MPS, and to prevent possible misuse of FPI route to circumvent the requirement of RBI's Press Note 3 on April 17, 2020. SEBI has sought public opinion on this paper by June 20. So the first part they are proposing, and second they have given the consultative paper, and public can give comments on 20th. As matter stand, it is become pertinent to discuss what could be the effect of this proposed USTA regulation on the securities market, the economies, as well as legal principles that govern it. Further, for the FPI, it needs to be deliberate whether the strict norms will help the market or lower FPI interest in the Indian market. Because if you tighten the law, then there is a possibility that people, the FPI may withdraw from the Indian market. The goal of this webinar is to deliberate and discuss the proposed suggestion by SEBI, by these consultative paper, and give suggestion comments on the consultative paper after deliberation during the webinar. I extend a very hearty welcome to all the learned speakers for today's webinar. Our first speaker is Mr. P.K. Vindalish, who is a former CGM. SEBI is a rank holder chartered accountant. He possesses over 42 years of broad quality experience in corporate finance, regulatory, investigation, and adjudication functions. During his tenure in SEBI, he had headed several departments and was involved in framing regulatory policies and investigation and adjudicating market misconduct in securities market. He has made a number of presentation, deliberation, talk at various national and international fora and led training program to emerging international security regulation. He has been a member of various committees constituted by SEBI, RBI, Ministry of Finance, MCA, International Securities Financial Services Authority, ICSI, ICI, and ISCO. He is presently providing advice on securities law and financial strategy. He is also sitting as an independent director on various board of reputed companies. So I welcome Vidalesh sir. You have demonstrated your extreme knowledge of the financial market, and the most important thing, the concept of economics of the market and the securities market specifically. Your word of wisdom always has given us a new direction and new dimension to the particular thing, and your knowledge in the security market, which is coupled with your chartered accountant background, will add the new flyers. So we hope that your discussion today will help, and we will understand the basic concept of these two particular laws. What is the purpose SEBI has brought out this, and how this can be remove the menace of the market. So I welcome you there, sir, for this program. Then we have Mr. Ravi Prakash, Associate Partner, Securities Law and Corporate Litigation, Corporate Professional. Ravi is also a budding professional, budding advocate. He is working in securities law, and he dealt very deeply into the subject, and his knowledge is also par excellence, which he will demonstrate today. I welcome Ravi. Then we have Ms. Nikita Vijay, Senior Associate Securities Law and Corporate Litigation and Corporate Profession, and she has always worked in the securities law. So her practical experience in this will help us because when she worked on the investigation, inspection, and the registration process, she always get the new things and new issues and what the regulator thinks. So we will get benefited from their knowledge. So I welcome all my learned speakers, and I will request first our speaker. So the program structure will be like this. First, we will cover the prohibition of unexplained suspicious trading activities, proposed regulation of SEBI, and Mr. Vidalesh, who has dealt in this various type of things in the investigation and adjudication. He will give his opening remark, and then Ravi Prakash will discuss this issue. Then second topic will take up this the FPI. Again, Mr. Vidalesh will give the opening remark, and then Nikita will cover the topic, and after that we will have a question answer. So without wasting time, I will request our guest of honor, Mr. Vidalesh, to share his word of wisdom. Sir, you have to unmute yourself.
Thank you, Mr. Pavan Vijay, for giving this opportunity to address the audience over here. I understand that more than 200 participants are there in this seminar, web seminar, which you have started when the COVID took in India. And I'm very happy and congratulate you for coming up to the 131st seminar in this duration. I think you have not missed any week where
Yes.
the seminar was not held. So that's a very big achievement, and I congratulate you for that. Now, coming to the topic of this consultation paper, the regulation itself, the heading of the regulation is the prohibition of unexplained suspicious trading activities in the securities market regulations. So first of all, we have to understand that when we already have the prohibition of fraudulent trade practices and the insider trading prohibition regulations, what is the need for going for this kind of another regulation? Will it be overriding of those regulations? Will it be the regulation which may contradict certain things between the or them overlapping also? So how to deal with that kind of situation is going to be very, very issue which SEBI has to deal while framing the regulation. Because I have seen the regulation very plain regulations, it's a general regulation that you talk about certain definition, then you talk about some activity, and then you talk the investigation. There's the same process for every time. Then they got the penalty, this and that. That is our standard thing. So it is very, very carefully to be seen what is the need for having this kind of another regulation. From the tone of the paper, it appears that SEBI is feeling somewhat uncomfortable, I will not say helpless, some uncomfortable in the changing technological environment, where it is being difficult for the regulator to really pinpoint the culprits, though they feel that thing, and prima facie it appears that there certain wrong has happened in the market. But due to the changing technical environment where different kind of things are being available to the participants, and the SEBI is not able to pinpoint and penalize the person who done the misconduct in the market. And whenever any misconduct, whether it is insider trading, it is fraudulent trading, unfair trading, pump and dump, it may be any sort of thing it may be, when it happens, it erodes the credibility of the market, and along with that, it hurts the investor's interest also, because the price discovery gets vitiated. But the one of the prime objective, though we always call the investor protection is the prime objective of SEBI, we maintain that thing. But the prime objective, if you see in the market, is the fair and transparent and equitable market should be there. That it should be available to all the players, it should be available the same opportunities. One should not be able to take the benefit of the information asymmetry. So SEBI, when felt that this kind of situation is happening, and they quoted certain examples also in their paper, that where they found everything, their suspicion. Mr. Pawnji also talked about that the number of transactions, alerts, because I know that results were regularly we are getting those alerts. We used to get these alerts. And then if to follow up on the result, this alerts, and to come to the conclusion become very, very difficult if we don't have the corresponding evidence. Though the preponderance of probability gives us some leeway where we can charge a person if we can presume that if this thing has happened, then what is the outcome of that? So, but it was very, very difficult. And now of late, judiciary has also raised the level bar for the evidences. Earlier, we were seeing that in the civil matters, because all the penalties you impose under Section 11B or the education penalties SEBI imposes, these are civil matters. And in the preponderance of probability was taken in a right spirit by the judicial authorities. Of late, but we are seeing that the bar has been raised, and the evidences which is being asked for is beyond the preponderance of probability. And it has become very, very difficult for the regulator to come to these finalities that yes, can we have got a good evidence to charge a person? Because in financial crime, in today's environment, it is very, very difficult to have a smoking gun. That this is the gun where the murder has happened. It is not possible. So we have to depend on the circumstances and evidences. The trading pattern is one of the biggest part, which give us the starting point for any investigation. Once the suspicious trading is there, then this all things start from there. Then, but after suspicion trading, when we are not able to do anything, so what now this is the new thing that is happening. People use a mule account, that you will hire certain accounts which are available. We have seen in the case of the IPO scam also that how the multiple demat accounts were available for just 1,000 rupees or 2,000 rupees, where you can make the application and then corner all the shares. So this time, so mule account is a mule account is a big problem right now. And having the mule account creates another issue. Your all links are broken in between, because now what is happening, the people are dealing with their own money, and what are the profit they generate, they just send it across to the person in black, in the cash they will send it, or hawala will be done, or something like that will be done. So it becomes very difficult. And when they are communicating, the communication taken from such platforms where it is not possible to track. Now the new features are in the system, the disappearing message. You make a message, suddenly it will disappear. Or you say, okay, after 1 month, it will disappear. Or you delete the message, give the message and delete the message. So it is become very, very difficult. And then people are communicated on WhatsApp, FaceTime, Botim, so many other Telegram, these things are coming. And this is because the challenges for the SEBI to take care of the thing. So in this scenario, this paper has come. But is it the solution, or it may create certain issues in time to come for that matter? The one of the issue with they are not going to go into detail of the what they have regulations they have provided, because Mr. Ravi Prakash will go and detail into that. But I want to raise certain issues in this paper which has come. That one of the big things has happened, that onus of proof has been shifted from the accused, from the prosecutor to the accused. And that is a big shift in the whole approach. Though we have some deeming provision in the takeover regulation also, insider trading also, but this deeming provision is not the absolute provisions. On that, just on that basis, you can't charge the person. Here, what I'm finding is that only the deeming provision is a thing where you can charge the person, and that is not a deduction. I understand, because seeing the judicial, I have dealt with the judicial matters also in SEBI, in area, because I have also issued so many orders, regulatory orders, that to stand the judicial scrutiny of this kind of approach may be a tough time for SEBI. Because you explain, and then you say, explain why it not be termed that you have done a wrong thing. And some exemption, they go, okay, you can give this explanation. Then it comes the documentary evidence. From where do you get the documentary evidence? You say your defense case, say, I have not worked function on this kind of information. So what documentary evidence I can give? I can't give any documentary evidence for that. So these are going to be challenged. And seeing the scenario over here right now, where the information is flowing, whether authorized, unauthorized, through social media, various channels, media, day in, day out, if you see any channel, business channel in the day in, day out, they are just throwing out the information. I can quote one example. In one case, in one big bank, what has happened, that something came in the media that 10% stake of that bank is being taken by one big international banker. And the price went up immediately, about 8-10% price jump. And then after 3-4 hours, they said that this information is not correct. So information is flowing in. So to charge the people on this basis and then say, prove your innocence, it is a bit, I believe, is an issue which need to be dealt with properly. Then I have another issue, that whether do we require a separate regulation for this thing? Can it be somewhere accommodated in the existing regulation, making some accommodation over there for this kind of transactions instead of going for the separate regulation? Because I have seen that separate regulation create confusion. Right now, the two regulations for the unfair activities are there. One is the insider trading, where it is very clear that inside information is being acted upon, then that is insider trading. Otherwise, or manipulative, pump and dump, so many this front running, manipulation per se, cornering, these structured trade, these all covered in the FUTP. So whether we require this regulation or not, this need to be deliberated quite in a quite big way. That if we come to this conclusion that these regulations are extremely required, then only I have the view that we should go for a new regulation. Otherwise, we should try to accommodate these kind of activities in the existing regulation. And third, I feel that we did not increase the litigation. Now also I'm seeing that wherever a reasonable order or it is a order which have impact on the something impactful order is being passed by SEBI, all are being litigated. Whether it is a SAT, or then if it did not get decided in the SAT, any party dissatisfied, then they move to the Supreme Court. Whether these kind of regulation will, where you have just put the onus on the accused to prove innocence. The basic law says a person is innocent till proved guilty. Here we are saying you're guilty till you prove innocence. So will this kind of regulations create that kind of scenario where the excess litigation will be there, and the resources of the SEBI will be diverted towards dealing with the litigation instead of doing the market development or other activities required, regulatory activities required to be done. So these are the things which the SEBI should look into, the broader issues which SEBI should look into before finalizing this. Certainly, it is very easy to make the regulation, but to then mandate that this oversee those regulations and to come to the effectiveness of those regulations have a certain, because a lot of people work on the basis of unauthorized information also. And then now we're bringing another concept of material unpublished price information. Then I don't know that how to differ from the unpublished price sensitive information. If any information is an impact on the price of the security, that is unpublished price sensitive information. So here to differentiate, then this will also become a good game for the advocates to just contest on that. If you charge under this regulation, they say it is UPSI, it is not the MPSI. And if you charge under this regulation, this is not UPSI. So generating new kind of terminology, and which may be misused also, maybe also a challenge for that thing. I think that the wider consultation will take place on these regulation, and something better will emerge out of that thing. And let us, it should not be hurried up. This is why my suggestion to the SEBI also, that it should not be hurried up, and more consultation should take place on this. Thank you.
Thank you, Vindleji. You have given this particular interpretation with your knowledge and your expertise in this area, that you have given order and that has challenged in the court, and then you must have discussed that what are the issues is pending, no doubt. Most important thing which you have said, the guilty till prove innocence is the worst word in the entire new regulation. So we have to just see whether this will create some new area. That is number one, a new confusion, new litigation. Second is, in the process, either because so many transactions will be suspicious, so any person who has a doubt, who can ask this type of question, or they can ask the various, they can start various investigation. So here, if SEBI can put check and balance, that is better. So it is not for anybody and anything you are asking question. Second, it will increase litigation. These are the two things. And last point which you have mentioned, that whether existing regulation was sufficient, you can add certain things, or you have to bring out something new. So if I was reading this, so why can't we bring out in the unfair trade practice? Because in this particular consulted paper also, SEBI has discussed about the unfair trade practice. So this is also unfair trade practice, and they can add the new definition, new point, and can bring out. Now let's discuss first that what is this law. Ravi will explain, then we will further discuss in the panel discussion. Okay, over to you, Ravi.
Thank you so much, sir. And because Mr. Bindlesh embarked upon the fundamental notions on which the consultative paper is brought about, I would start from there. I would try to not repeat what he has already captured, but for the benefit of in-depth discussion, I might again touch upon few aspects. So let us first understand what is the underlying assumption or the underlying facts, or as we may call it, background, in which this new USTA consultation paper, or the new regulatory framework, as SEBI itself calls it in the consultative paper, is proposed. So the first slide is regarding the background This essentially tells you what SEBI has realized, or it offers as an underlying assumption for this concept paper. The first one is that manipulation, fraud, unfair trade practices, insider trading, front running, pump and dump, all these contraventions, they undermine market integrity. There can be no doubt about it. Second one is also pretty lucid to understand, which is that it is SEBI's responsibility, or maybe as one may articulate, paramount objective to protect the investors. Third one is the problem statement, that market participants are increasingly using new age technology and novel methods to commit fraud while hiding their identities and relationships. Fifth is again a mix of problem statement and what SEBI is already doing. It realizes that although the surveillance system is raising red flags and alerts, but these innovative techniques, encrypted communication, complex fund arrangements, using new age technology as well as human ingenuity, is making SEBI to enforce on the red flags comparatively harder than ever. Point number 5th and 6th are again a problem statement and also reflect on the process followed by SEBI so far. You would see that SEBI has recognized and realized that they have been following the principles of preponderance of probability to hold violators accountable. As Mr. Bindlish pointed out, that there would not always be, and in most of cases, a smoking gun available as a clinching piece of evidence. So you have to build your case on preponderance of probabilities, as getting conclusive evidence is difficult. That's what I meant by clinching evidence. So you see the word, before we dive into the consultative paper, let us understand what is the concept of preponderance of probability. For short, we will be calling it POP. And the concept is not new and not only recognized in India. It is a concept which is recognized all across the world, especially in common law countries. And the preponderance in legal sense is the degree of cogency required to discharge a burden in a civil case. Preponderance, if you interpret it literally, and this is one from the Allahabad High Court, the precedent is still an authoritative one, rendered in case of Rishikesh Singh and others versus the state, decided on 18th October 1968, almost 5 decades ago. They say it means nothing more than an outweighing in the process of balancing, however slight may be the tilt of the balance or the preponderance. So they say that if evidence is not clinching, it is not conclusive, then you have to weigh different factors, different circumstances, different conducts, and different arguments against each other and balance them. If the balance leans in the favor of innocence, it goes towards exoneration. And if the balance leans towards the guilt, then the enforcement actions can be taken. Now, I understand that whatever I said so far is too broad and probably to a certain extent vague for the audience to understand the concept of preponderance. And more than even if someone is able to understand it because of the prior knowledge or reading of the subject, many questions would still be arising in the mind as to how to apply in a practical situation the principles of preponderance or POP. Going forward, I will try to, although this is a mixed, it's not a pure question of law. Preponderance in itself is a mixed question of law and facts. It is an art as it entails appraisal of appreciation of evidence, investigative functions, and then to some extent ends with a judicial or a quasi-judicial function. So therefore, I do not boast that we will be able to break it down in this limited time program, but I think it will give a good inoculation to the audience and those who are professionals or aspiring to work in this area of decoding the FUTP regulations or practicing on it, or those who are dealing into the markets. It will tell them what risks they may fraught, or what are the considerations they should keep in mind to keep their conduct above the board while dealing in securities market. So you see, the concept of POP is not new, as we already said, 1968 judgment. If you look at the Western world, it is even more ancient. 1857, 52, 59, from House of Lords, there is a discussion on this concept. They say it is more preponderance, probable, and rational view of the case. So they say, in a way, that preponderance is applying the prudence and reasonable man test, because there is no clinching evidence, to come to a logical conclusion of the matter at hand. But since it is ancient and probably archaic, and it still doesn't offer much perspective on how to apply it, we would move forward and see what our legislation, the primary one, which is the Indian Evidence Act, mentions about proof. So when we say something is proven or something is proved, what does it mean? Let us see. It is on your screen. You may also read, and for the facility, I'm reading it from the screen. A fact is said to be proved when, after considering the matters before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. In Rishikesh Singh's case, there were three categories that the court identified. One is proved, which you see is also mentioned in the definition. One is disproved, which is non-existence of circumstances as proved until disproved. To put it in simple word, reverse of what is proved would be disproved. Suppose if I'm going to prove a fact by positive means, and if the party who's defending disproves the fact by a positive mean, that is disprove. There is a third category, which is not proved, which is the concern, as Mr. Bindlish also told, that SEBI is facing. That even though have some red flags, a higher level of suspicion, they are not able to prove it or stand the legal scrutiny in the courts. Now we'll quickly go to the concept of preponderance from a strict judicial sense. In the case of Narayanan Ganesh Dastane versus Sucheta Narayanan Dastane, It is also case from 1975 from the Supreme Court of India. It says when the court either believes it to exist or consider its existence so probable that a prudent man ought, under the circumstances of the particular case, similar to what we discussed on the previous slide, based on Section 3 of the Evidence Act. It is verbatim written from there. But let us also see what Black's Law Dictionary says on it, because so far as we have seen that the judicial precedents as well as the legislative provisions are putting it on the shoulders of the court and their belief. Now, if the duty is on the court and their belief, we would also see going forward in the upcoming slides as to on what basis that belief or that opinion can be formed. So if you see the Black's Law Dictionary, they define this preponderance of proof or balance of probability as the greater weight of the evidence, not necessarily established by the greater number of witnesses testifying to a fact, but by evidence that has the most convincing force, superior evidentiary weight that, though not sufficient to free the mind wholly from unreasonable doubt, is still sufficient to incline a fair and impartial mind to one side of the issue rather than the other. This is the burden of proof in most civil trials, in which the jury is instructed to find for the party that on the whole has the stronger evidence, however slight the edge may be. The keywords are that it is such evidentiary weight that, though not sufficient to free the mind wholly from all reasonable doubt, is still sufficient to incline a fair and impartial mind to one side of the issue rather than the other. Now, so far on the application and the connotation, so far on the connotation of preponderance of probability. Now let us come to the concept and its application and the risks involved and the dangers involved in applying this concept, which has been beautifully captured by Supreme Court in two of the judgments. One is fairly recent one and directly pertains to SEBI, passed in 2017. And the second one is, again, half a century ago, but again comes from Supreme Court and lays down the principles and the dangers and the risks involved with application of this principle in a lucid way, or at least comparatively more lucid way. So the first case is SEBI versus Kanhaiyalal Baldev Bhai Patel and others, decided by Supreme Court on 20th of September 2017. In this case, the Supreme Court held that you may take inferential conclusion, which means you may take an analogy or an inference from the proved and admitted facts, and that may be permissible and legally justified to take an enforcement action or to say that a particular thing has been proved so far as the same is reasonable, which means the analogy is reasonable and has direct nexus with the objective which is sought to be achieved. A more nuanced view or a word of caution was given by the Supreme Court long back in case of Hanumant versus State of Madhya Pradesh. The court held that in dealing with circumstantial evidence, the rules especially applicable to such evidence must be borne in mind. So here, clearly, the Supreme Court is saying that the preponderance of probability is not a free ground. It is also regulated by the rules of evidence, and it should not be understood that in this territory, whatever assumed, whatever presumed becomes evidence or gains weight, particularly evidentiary weight, and they say that it has to be bound by the rules especially applicable to such evidence. Let us read further and find out what those rules are. In such cases, they say there is always the danger that conjecture or suspicion may take the place of legal proof. It is well to remember that in cases where evidence is of a circumstantial nature, the circumstances from which the conclusion of guilt is to be drawn should in first instance be fully established. So they say that the circumstances from which one is wanting to draw the guilt or the conclusion of guilt should be fully established at first. Need not to move the trolley forward unless until you fully establish the set of circumstances or facts from which you are going to draw an analogy or inference of guilt. All the facts so established, this is the second caution, all the facts so established should be consistent only with hypothesis of the guilt. Again, the circumstances should be of a conclusive nature. Third caution. And they should be as such to exclude every hypothesis but the one proposed to be proved. So it means that from the same set of circumstances or facts, only one plausible or reasonable hypothesis should be coming out, and all other hypotheses that are being attempted to be built or drawn, they all fall short of the prudence man test, or they do not look as plausible, as reasonable as the other hypothesis looks. So this is race between hypotheses. The hypothesis which would have direct nexus with the facts and the objectives, which is based on the facts which are not in dispute, or the facts are proven or admitted, and the hypothesis is also reasonable in all aspects, is the hypothesis which will win this race of preponderance. There could be many theories arising out of same facts, but the one which satisfies all these principles will win the race, and based on that chain of analogy, one can say that preponderance of probabilities have been satisfied. In other words, there must be a chain of evidence so far complete as not to leave any reasonable ground for a conclusion consistent with the innocence of the accused, and it must be such as to show that within all human probability, the act must have been done by the accused, which is the same thing, I put it in different words. Moving forward, there are again a couple of judgments in Sterlite Industries India versus SEBI. It is a decision from SAT rendered in 2001, where SAT also cautioned that evidence merely probabilizing and endeavoring to prove the fact on the basis of preponderance of probability is not sufficient to establish a serious offense of market manipulation, because they say once it is investigated and charge is established, the fallout of the same is multifarious. So one cannot do it casually. They say merely probabilizing and without proving the foundational facts, you can't rope in this principle of probabilities to bring your case or bring the charge to a logical conclusion. And then again, in Chintalapati Srinivasa Raju versus SEBI, this is also fairly recent, of 2018, the court has said that a reasonable expectation to be in the know of things can only be based on reasonable inferences drawn from the foundational facts. I took so much time to explain this concept because this is the concept based on which this entire schema of USTA, proposed USTA regulations are being based. This single concept is the mother source of this entire proposed regulation. And this is going to operate on these principles only because, as I said in the first slide, the foundational fact that SEBI has asserted as an underlying assumption for this consultative paper is that there are challenges that they are facing in collecting conclusive and clinching evidences in these kind of offenses. So the examples cited by SEBI for these kind of offenses are front-running cases, cases where before a company comes out with an announcement which has a bearing on the scrip price or which may have bearing on the scrip price, people start taking position. And then again, subset of the second, which is the announcement, is that in specific cases, SEBI found that before financial results were published, people were taking positions in the scrip. Those positions, if the financials are good, they're going to bolster up the scrip. People buy, which is the long position, and if it is going to dampen the scrip, then they take an exit. So you see, in all these three cases that SEBI has cited, there is a common thread running, which thread is or can be said to be of an information which is asymmetrical or asymmetrically available. It is available with a few, but not available with the public at large. So the gap of information is the running thread across these three examples cited by SEBI in their consultative paper. Now let us discuss in more detail what are the difficulties faced by SEBI. One clear difficulty is the lack of evidence and difficulty in establishing communication of material non-public information or connections between suspected entities, which hinders the legal scrutiny or even keeps SEBI from pursuing these cases further. As Pawan sir quoted, in 2022, SEBI's own alert generation model produced around 5,000 alerts involving 3,588 unique entities. Only 97 entities were repeatedly appearing in 5 or more alerts, indicating suspicious trading pattern. Most of this could not be acted upon for the difficulties already explained before. And 60% of detailed investigation cases could not proceed due to insufficient evidence of information communication. Even in the remaining 40% of the cases, establishing communication of material non-public information proves challenging due to varying evidentiary requirements. Probability of executing repetitive fraudulent trades is very low considering the large number of daily trades in the equity market. So they are trying to indicate that you would not even find a lot of repetitive behavior in the same way, in the same manner, so as to establish that a person is repetitively doing the same kind of behavior. Because these people who do manipulation and fraud are generally intelligent people. The securities market is no game for faint-hearted and weak-minded. They are people of strong will and ingenuity. So they do apply novel methods and new techniques to defraud, and while hiding their tracks and patterns. So that also adds to the complication of resolving the puzzle. Now, in the consultative paper, let us now, from this point onwards, let us now deep dive into the consultative paper, taking it and deciphering it, at least the most crucial parts of it. After delineating on what difficulties is being faced by SEBI. Am I audible?
Yeah, carry on.
Yes. Yes. So after reflecting on the difficulties faced by SEBI, they have referred to two provisions. One is Indian and another one is international. One is Section 68 of the Income Tax Act, which says that if unexplained cash credit is found in the books of an assessee, that credit can be assumed to be assessee's income for that financial year, for which or in which it is found. And the second one is Section 11 of the Securities Act 1933 of the United States of America, which says that if the parties who are involved in securities offering, if their registration statement, which also means somewhere the prospectus or the offer documents that they issue, if it contains a materially false statement, or if there is a material omission, then they are deemed to have committed an offense. While these two provisions are interesting to note, I feel that Section 11 of Securities Act 1933 is well captured by SEBI as false statement, misleading disclosures are already a punishable offense in the SEBI Act 1992 and the regulations that are made so far to administer the Act. So far as this Section 68 is concerned, I mean, I'm not remarking it in a way that I am completely dissatisfied the analogy taken in the consultative paper, but I see a stark difference. While in securities market, you invest, and at least in this age, you invest through your bank accounts and through the money which is duly accounted for. The presumption on the basis and jurisprudence of presumption, and it is for the audience to go and read about the commentaries on Section 68, why it was brought about, why such a presumption was introduced, you would see that the presumption of unexplained cash is far from the assumption they are going to take here. And they do not stand on the same footing, because unexplained cash credit in itself and has always been a matter of concern for income tax authorities, because these authorities, they do not set the rules nor they monitor how you earn your income. The legislation is concerned with taxing the income and not in regulating the income. But in securities market, the entire architecture is regulated. You participate through registered intermediaries, and within the four walls of the architecture that is designed by the regulator and the infrastructure institutions over which the regulator has ultimate control. So therefore, I feel both the Section 11 analogy from Securities Act is needless, because you already have these provisions to punish such offenses in your own home legislation. And so far as Section 68 is concerned, that presumption kicks on different considerations, and it has a different jurisprudential basis and a compelling interest, which is different than what is here in securities market. So I feel that these two are not paramateria. Now, the entire USTA regime is running on three things, or rather four. One is unusual trading pattern, which means that repetitive pattern of trading activity by a person or group of connected person, which involves a substantial change in risk taken in one or more securities over a short period of time, that you take heavy exposure and within a short period of time you change the beneficial ownership, or you reduce that exposure and again take that exposure in a cyclical transaction, which cyclical transactions or a singular isolated transaction even results in abnormal profits, or it averts abnormal losses. Then the second one is deemed unusual trading pattern. This is more dangerous. It is say that even if individually my pattern does not appear to be unusual, I may be linked with persons or group of persons, and my conduct will be seen under the lens of the overall conduct of the group or the so-called connected persons. The legit question which comes to mind is, what are the parameters for connecting me to that group of persons? And this is going to be a challenge going forward for SEBI. Now, the next element of this is material non-public information. In previous webinars, wherever we were analyzing insider trading provisions and the concept of UPSI, I vividly remember studying the provisions of United States on securities law in the framework of SEC. And this term MNPI is ditto same as what is meant by UPSI. There is no difference. In fact, in different jurisdictions, MNPI is used by regulators to define what we call as UPSI. And if you read the first point, which the consultative paper gives for the definition about MNPI, how they define it, they say information about a company or security which was generally not available and upon becoming generally available had reasonable impact on the price of the securities of the company. This is what UPSI is, with grammatical variations. So you see, MNPI is UPSI. So they've tried to carve out some differences, maybe by broadening it further, but it largely remains UPSI, or we may say, at least for now, one can safely say that every UPSI is an MNPI. Or if MNPI is a term which has broader connotation, then every UPSI is an MNPI. MNPI could be beyond what is UPSI. And then the third element is suspicious trading activity. Now, what is suspicious trading activity could be understood by the equation given below on the slide. And the same equation is also given by the SEBI in its consultative paper. I must thank SEBI. I mean, whatever is going to be fate of these proposed regulations, that apart, they always work hard in bringing the empirical data and explaining their concepts in lucid terms. And I think that serves the purpose of public consultation as well. And that is why we are able to discuss as to what difficulties, what challenges this USTA will face, and at the same time, what good changes it is capable of bringing. So suspicious trading activity is unusual trading pattern plus existence of material non-public information. So if there is a unusual trading pattern which coincides or which is in proximity of a material non-public information, it becomes a suspicious trading activity. And a suspicious trading activity which is not explained with documentary evidences becomes an unexplained suspicious trading activity, hence the name USTA. That's what USTA stands for. That your trading pattern is unusual, number one, move forward. There is an MNPI, all right, it becomes STA. At this point, what the proposed regulations, which is only a set of 6 regulations so far, yes, 6 regulations, in which one is about the short title and commencement. Second one gives about definition. So effectively, there are only 3 regulations, effective regulations. 3, regulation number 3, which prohibits USTA. 4, which I'll come later on and speak about it, because this in my opinion is most startling. Obligation of stock exchanges and intermediaries. And 5th, which is about investigation. So let us deal with fifth first, because we have discussed the concept of USTA. So the moment there is an unusual trading pattern and the regulator observes that the trading pattern is in proximity of some MNPI, they will form an opinion and they may launch an investigation. What will happen if they launch an investigation? At this stage, when they launch an investigation, the burden of proof is reversed, and it is Regulation 5 of this USTA which reverses the burden of proof. It says that the persons on whom investigations is launched, they have to rebut the allegations by demonstrating. Can we have the next slide, please? Yes. They have to rebut the allegations by demonstrating that the trading activities were not suspicious, and how they may give the rebuttal. Regulation 5 also tells about it. They say that such rebuttal may include but not restricted to any of the following. First is that the person has to prove that the information which they possess, it does not meet the test of MNPI, which means that the trades were not based on information that was material. The trades were not based on information that was not available in the public domain prior to, in the vicinity of trading undertaken. Second is that trading pattern was not repetitive. Third is trading pattern does not exhibit substantial change in risk taken. Fourth is period for which trading was undertaken cannot be categorized as short period of time. And fifth is that trading activity did not deliver abnormal profits or avert abnormal losses. I thoroughly feel that on all these 5 pointers, there would be very sore litigation, if at all, in its current form, these regulations are brought about. And when I say sore litigation, it means that the litigation, at least the moment these regulations are pressed into action, these will be faced with challenges on different aspects, which arises to my mind, and my views are strictly personal in this regard. It does not represent view of any body of individuals or any firm or any other organization. But I say so because this USTA proposed regulation is turning on its head the rules of evidence, quoting that the evidentiary machinery or the collection of the process of collecting the evidence is proving to be very challenging. Now, interestingly, in SEBI Act 1992, there is an exemption from the rigors of Indian Evidence Act. The Evidence Act does not apply in its strict sense in these proceedings, or by that I mean any proceedings under SEBI laws, as much in the same capacity as it applies in an ordinary civil or a criminal trial. So therefore, the leniency was always with the regulator, because the strict rigors of Evidence Act does not apply. The entire idea was to give the freedom or the swiftness to SEBI to take actions and not to be thwarted by these dilatory tactics. Secondly, these regulations are framed under Section 30, which says that the board may, by notification, make regulations consistent with this act and the rules made thereunder. So a probable challenge would be that the regulations are inconsistent with the act, because in the act, the burden of proof is not reversed. Although the consultative paper says, and it rightly says so, that in some cases, deeming fictions can be introduced. There are a lot of deeming fictions inside the law, in substantial acquisition of shares and takeover regulation, and there are a host of deeming provisions already in the law. But what Mr. Bindlish said on that aspect is monumental. It does not mean that merely by the deeming fiction, I can hold you guilty. And I can shift the burden on you. If you do not prove, then you are guilty and you are thrown to suffer the consequences. Most of the deeming fictions require some compliance, brings one under the ambit of a regulated framework, provide some sort of code of conduct for the people who are under the dragnet of those deeming provisions. But this is the only provision, or probably a peculiar one, where the deeming provision is akin to the deeming provision found under PMLA. So, on this count also, there would be constitutional challenges to this new framework. Now, if you see the bright side of it, or I would say the safeguards that I see in the consultative paper already built in. The consultative paper itself realizes that once the facts are established, then only an investigation will be launched. So, the nuanced view is that although the burden is reversed, but equally important is to check at what stage the burden gets reversed, and before the burden is reversed, what the regulator must do or ought to do even under these regulations. Even if assume that these regulations are today notified and they are standing in the statute book, then also the burden is not shifted on the people since beginning. The burden will be shifted once SEBI proves that there is an unusual trading pattern, that there existed MNPI, that the person concerned had access to the MNPI, and thereafter investigation is launched. Only thereafter this burden of proof will be reversed and the person can be asked to rebut the allegations. And to mind everyone here, it is the cardinal rule of evidence that a negative cannot be proven. Ordinarily, no one can be compelled to prove a negative, that I did not do this. I can prove a positive fact. I can't prove a negative fact. It is very hard to prove a negative fact. There are exceptions to it. When the matter relates to personal knowledge of an individual, then this principle has some nuances which applies, but ordinarily a negative is not called upon to be proved. It is the positive which has to be proven. Secondly, one of the yardstick for pushing this USTA is abnormal losses and abnormal profits. I feel that that the entire securities market functions on information, perception, and risk appetite. These three are the factors, maybe psychological factors or real factors, that affect the demand and supply mechanisms and manifest into market behavior. So therefore, what is abnormal, what is normal is also a matter of concern and how it will be applied. All in all, my view on these regulations is, although the purpose is very benign, it is to save a lot of investors from the heat of these maligned elements into the market or these kind of manipulative activities. I feel that if this kind of a law is implemented, this might also bring along with a lot of good things a huge abyss of uncertainty, which may also go against the class of investors that the regulator is trying to protect. Because once you are under the lens of suspicion, no one looks at you as an innocent investor. And a lot of people might face the heat of, enforcement actions being prey to these, tough provisions. So therefore, essential safeguards should be built. And as Mr. Bindlish said and recommended, these should not be brought with haste. There should be some deeper consultation and deliberation on the topic. I think that's all from my side. We are yet to see what kind of exercise SEBI is going to do in the matter. And then probably we can better deliberate on the issue.
Thank you, Ravi. Thank you very much for giving an extensive analysis of this law, including the law behind the this concept. No doubt, it's a very challenging time, and the issues are challenging. We will discuss in question answer. Before this, there is another consulted paper on foreign portfolio investment, which we have mentioned that SEBI is asking the ultimate beneficiary for this. We are aware that in company law there's a beneficiary interest BPO, and then we have the PMLA law, and then in SEBI law also. But SEBI want to strengthen the foreign portfolio investment process, more strengthen. So what are the law? What are the things? Over to you, Nikita. Nikita, we have a short of time, so we have to.
Yes, sir. Thank you so much, sir. Before discussing the discussion on the consultation paper, so basically the objective behind coming up with this consultation was twofold. First, they wanted to guard against the possible circumvention of the minimum public shareholder under the curtain of being in foreign portfolio investment. Second, to guard against the possible misuse of the FPI route to circumvent the requirements of Press Note 3. Press Note 3, which has come during the COVID time, where any investment coming from the land bordering countries from India has to be come through the government route. So before delving into the specifics of foreign portfolio investment, the disclosure requirement that has been proposed by SEBI, we should first understand that what is a foreign portfolio investor. So foreign portfolio investor basically refers to the purchase and sale and holding of a wide array of financial assets by the entity seeking to invest in a country outside their own. Further, it can have access to a range of investment instruments such as stocks, bonds, mutual fund, derivative, fixed deposit, etc. In India, FPI is being regulated by Securities and Exchange Board of India. Further, FPIs are currently classified into two categories. So category 1 generally includes the government-related entities, pension funds, university funds, and regulated financial entities. The entities which are appropriately regulated, such as insurance, reinsurance, and entities, banks, AMCs, investment managers, etc. Also, the entities from FATF member countries with registered members are also allowed in category 1. Further, in category 2, it includes the regulated funds which are not eligible under the category 1 FPI, endowments and foundations, charitable organizations, corporate bodies, family offices, individuals, and unregulated funds in the form of limited partnership and trust. So now comes the role of the designated depository participant. So basically, designated depository participant is the custodian of the securities who is registered with SEBI. It is empowered to register and certify foreign portfolio investors on behalf of SEBI. Further, they also have a role to ensure that only registered FPIs are allowed to invest in the securities market. And they have also the duty to perform, amongst the other duties, they have also the duty to perform KYC due diligence for each of the joint holders. Now, coming to the KYC due diligence, one of the KYC requirement is to identify and verify the beneficial owners of the FPI, which is the core of this consultation paper. So, if we talk about the existing regulations on disclosures of BO, in India, the PMLA, the Prevention of Money Laundering Act and Prevention of Money Laundering Maintenance of Records Rules 2005 provide the framework for identification of beneficial owners. So PMLA Act defines an individual who ultimately owns or controls a client of a reporting entity, or the person on whose behalf a transaction is being conducted includes a person who exercises ultimate effective control over a juridical person. So as the term says, when it just wants to tap upon the natural person who has the ultimate control on the said entity. So beneficial owners can emanate from three of the criteria. One is the ownership criteria, second is the economic interest, third is the control. So it can be identified through various parameters. For example, what is the shareholding of that natural person in the entity? What is their economic interest? Whether they have any control to right to appoint any directors or decide any policies for the entity. So moving forward, under the PML rules, the procedure to identify BO has been discussed. So at the first stage, the materiality threshold is applied in the FPI level. The materiality threshold we will discuss in detail in this second slide. And at the second stage, if that materiality threshold at the FPI level meets, then then the DDP has to identify the BO on a look-through basis until the natural person of the beneficial owner at the end of the chain is detected. But there are circumstances because there are entities which have, if you see individually, they are below the materiality threshold, but ultimately with layers and layers of the corporate entities, they are being layers of the corporate entities, they are being controlled by only one natural person. But since the individual entity is below the threshold, the second stage never comes while detecting the identification of the BO. So in case when no natural person is identified, then BO is the relevant natural person who holds the position of the senior managing officer. So what was happening? What was the issue that was being faced by the by SEBI while detecting the beneficial owner? So people come into an arrangement where they transfer their rights and voting rights, and the person who has the main economic interest in that entity then never gets disclosed under the current scenario. So any changes occurring during the whole procedure has to be informed to the designated depository participants. Now coming to the threshold for identifying beneficial owners of the legal entities based on ownership and entitlement and profits as per Rule 9.3 of the PML rules. For corporate and trust, in May 2023, there was an amendment, and for corporate and trust, it was 10% of the controlling ownership or in trust and any other natural person exercising ultimate effective control over the trust through a chain of control or ownership. And for partnership firms and unincorporated association or body of individual, the threshold was 15% of the property or capital or profits of such association or body of individuals. What were the potential issues that were flagged by SEBI? So SEBI was of the view that, as I told, that the shareholding and the ownership were divided into several entities, and they never they never cross the material threshold. So they were of the view, because of this, there are certain FPIs which are circumventing the minimum public shareholding norms as issued by the SEBI. So in wake of the recent Adani Hindenburg case also, in the expert panel report, which was published on May 6, 2023, they have also addressed this issue that since the SEBI was facing difficulties while assessing that who is the ultimate beneficial owners of the foreign portfolio investment, there was a need for a change. And if you see, within 21 days, SEBI has come up with a consultation paper on May 31st, 2023 to tap this issue which were being faced by the regulator. So the same natural person holds an aggregate economic interest in the FPI through various investment entities, none of which individually exceed the materiality threshold, as I have already discussed. The second concern was regarding the Press Note 3. Press Note 3 mandated that FDI from neighboring countries sharing a land border with India, or where the beneficial owner is a resident of a country sharing a land border with India, must invest only through the government route, regardless of the original entry route. It was initially introduced as a measure to prevent opportunistic takeovers of these stressed and strategic assets or entities in response to the impact of the COVID pandemic. what is the proposed changes? So what SEBI is proposing right now is this. Currently, FPI has been categorized into two categories, that is category 1 and category 2, as I discussed earlier. Now they want to further categorize into low risk FPIs, moderate risk FPIs, and high risk FPIs. So low risk FPIs are generally covers government, central bank, sovereign wealth funds, since their ownership, economic and control interest in such entities is known due to the predominant ownership by the government of the respective country. So they are covered under the low risk FPIs. For the moderate risk FPI, they are pension funds, public retail fund. These funds have a wide and dispersed investor base. So subject to the ability of the DDP to independently validate and confirm the status of such FPIs as pension funds and public retail funds, these funds can be categorized in the moderate risk FPIs. Now coming to the main category, which is high risk FPIs. So this whole consultation paper is based on the high risk FPIs. They want the granular disclosures from these FPIs, which are not covered either in the low risk FPIs and the moderate risk FPIs. So the risk classes can be or should be coupled with either the quantum of concentrated investment by FPIs in a single corporate group, or the size of the overall equity asset under management. Asset under management is basically the total investment made by that specific foreign portfolio investor. So the high risk FPIs, if they are holding more than 50% of their equity of asset under management in a single corporate group, then they have to comply with full disclosure without paying any heed to the materiality threshold, which were earlier there as per the PML rules. Secondly, if the high risk FPIs have exposure below 25% of their overall AUM, they can be reclassified as the moderate risk FPIs. So basically in this case, this is a sort of an exemption that has been given by the SEBI in its consultation paper, that if they have an Indian oriented AUM that is relatively low with respect to their overall investment at a scheme level globally. So DDPs can validate the same, and if those kind of FPIs have exposure below 25% of their overall AUM, then they can be reclassified as the moderate risk FPIs, and they do not have to comply with the granular disclosures of disclosing the ultimate beneficial owners. So these additional disclosure requirements won't impact the moderate and low risk FPIs. This is basically applicable only on the high risk FPIs. And these both cases are applicable in both prevention of circumvention of MPS also and prevention of misuse of FPI rule for circumvention for press note 3. Moving forward, so there's a timeline sort of given by SEBI in its consultation paper, that the new FPIs that have been incorporated, they can cross 50% of group concentration only up to 6 months without the need for additional disclosures. But beyond 6 months, additional disclosure will be triggered if the group concentration is above 50%. There's no such provision for the press note. There are separate provisions which we'll discuss later. So for the winding up FPIs, which are about to wound down, if they temporarily breach the 50% investment threshold in a single corporate group, they would not be required to comply with the additional disclosure, but provided that portfolio should be wounded up within 6 months. Now coming forward for the existing FPIs, if they have crossed, so basically this is for the if the existing high risk FPIs, if they come under the definition of high risk FPIs and they have 50% concentration threshold in a single corporate group, they will be provided a period of 6 months to bring down the exposures. And for the press note 3, the threshold has been given as high-risk FPIs with an overall holding in Indian markets of 25,000 crores shall also be required to comply with the additional disclosure within 6 months. For the ongoing high-risk FPI, so basically when this consultation paper will come in complete effect, the FPIs that will breach the 50% group concentration investment threshold will be provided window of only 10 days to bring down the concentration. Otherwise, they have to disclose make the additional disclosure of BO. Secondly, high-risk FPI that crosses the 1,000 crores AUM threshold in the future will be required to comply with the additional disclosure within 3 months. So there are certain points that have been captured by SEBI while issuing this consultation paper. First, they have said that as of March 31, 2023, around 2.6 lakh crores of FPI assets, 6% of total FPI equity AUM, may be categorized as high-risk FPIs, meeting the 50% group concentration or rupees 25 crore fund size threshold as given by the SEBI in its consultation paper. Secondly, high-risk FPI, they have also mentioned that high-risk FPI must submit an undertaking at registration waiving privacy rights in favor of SEBI. Existing high-risk FPIs have 6 months to submit that undertaking so that the transparent disclosure can be provided to designated depository participants. Third is FPIs to monitor threshold, but it is the duty of DTPs to notify breaches and take necessary action against the such breaches. Thank you so much, sir.
Thank you, Nikita, for giving this. Before going for question answer in this particular FPI, Vidalesh sir, what is the reason of SEBI bringing out this additional point for this FPI regulation?
I have not. Yes, please complete your question first.
So I'm just asking this portfolio FPI, SEBI wants to tighten this and they want to see the ultimately beneficiary, and they have given the various criteria. No doubt, internationally, if you are investing in any company, any jurisdiction, so they will ask you who is the beneficially natural person. But in India, it is slowly coming. Like first it has come to PMLA, then company law, now SEBI. SEBI was also asking. But what is the struggle in this and why people are not ready to give? And what is the logic behind this? Is it round tipping? Is it something else? Or some money which people don't want to disclose? What is the theory behind this?
Issue is manifold versus it's not a one side. The round tripping is the one part, which has already been having an issue with the Indian regulatory system. That because the taxation structure which we are having in India is a bit different than the other jurisdictions, and that gives a leeway. And what kind of environment is there overall? So people may generate certain other income which they not really disclose in India, and that round tripping takes place for that. So that is one concern that always remaining there. It was there when I think 92 when the FPI was allowed to come in India. At that time, this was a concern, and the Mauritius route is the most known for that, and that was always a concern. Is money from the Mauritius? There's something hanky-panky is there. That concern is always there. But the present thing which is coming out of that MP, they're taking the shelter of MPS, that what is the minimum public shareholding, on that being the issue. And because this is a paper, that is the underlying paper. Press note 3 is a sidekick. I don't believe that is the main thing for this paper. Main thing is the MPS. And MPS, why it is coming, though SEBI is claiming that we are looking at this issue since long, this and that. But somewhere it appears that the shade of Adani Hindenburg, the issue is there into this thing. And in any case, I personally also believe that MPS is a very, very serious issue, because the MPS has a impact not only on the floating stock and the market manipulation and trust and transparency, it also impacts the composition of the indices. Because the most of the indices are based on the free float. If free float itself is not calculated properly, then that may have an undesirable impact, and the investment may get skewed into that, maybe because so many indices are followed by the investor that they follow the indices for that thing. But MPS is always the concern for the SEBI. I still remember the first time which we looked into that was in 2000. Then clause 48 was introduced, continuous listing requirement. But that were not then were followed. I will not punish people, not punish for that. But till now, the SEBI is engaged with this issue. And this issue, MPS is not just international, it's a national also. That here also, we don't exactly know how much promoter is holding. What they're disclosing is the real they're holding, or is something they're holding in Benami, this and that question is there. So this aspect which is coming from MPS is a relevant issue, and the SEBI is doing the right, but I'm not sure that whether the this other side of the impact of this thing has been seen or not, or examined or not. That one is that will it impact the ease of doing business, which we are claiming that we want to make the ease of doing business in the agenda of the Prime Minister also, but that is the India agenda now, that we should have ease of business. And we are a capital deficient country, where we are looking for the foreign participation. So in that scenario, putting these kind of granular details, which generally people don't like, because I have also dealt with a number of funds, now I'm also dealing the funds, that they don't like to disclose beyond a limit. Because they want something, somewhere something should be, there is not always for the purpose of round tripping or taxation. There's certain other issues also there involved to that. So that may be an issue which SEBI need to consider in a deeper manner, that what impact is going to have on that. Otherwise, on the face of it, the proposed resolution is very good for that matter. And somehow 50% also don't understand why 50%, why it's not some other figure, that how that this figure has come of 50%, because nobody nowhere dealt with that. Why 50%? Why not 60%? Why not 40%? This paper does not delve on that. So I think it again, I say that these proposals are good for that matter for MPS, but MPS is not the ultimate thing. So many other things also to be seen. And they might certainly, the consultant committee has already looked into that matter. SEBI advisory committee might have seen into all these proposals. But it is good that they have come up with a paper, and all the stakeholders should give their comments on that. That what kind of challenges we are going to face. Though they are saying it is 6% only, which is going to impact by that thing. But at times, what happens when the sentiment changes, it doesn't hit the 6%. It has a wider implication onto that. So all things need to be seen in a very great details before implementing their thing. That's my view. Thank you. You are mute. Pawan, you are mute.
Oh, sorry. Okay. So thank you, sir, for giving this information relating to this relevant question. Let's start question answer. So I'm asking the question from you related to FPI. So there are two things. One is MPS. MPS means that you are having a 75%, you can hold 75%, but through some channel you are holding other equity also. And there is no doubt that when you are holding more equity than 75, then you are disturbing the liquidity, and you are concentrating, because if the market shares is less, then the market manipulation and these things are very easy. That is one part. But second is, there is a one point that FPI generally, when they invest in the market and you ask them that who is behind this, then they threat, we will leave the Indian market, we will do. So today, if they're leaving Indian market, what's the problem? We have more than earlier. When today, if FBI, this FII, they were taking any step that is disbalancing the market. If they're buying, market is going up. They are selling, market is going up. Now, if you, in the past, you have seen last 1 year, 2 years during the COVID, how the FPIs, how the FIs or FPIs affecting the market. I think that is not giving imbalance to the market. So the fear of the regulator and fear of the Indian policymaker is going away. Only point is, if they are asking who is behind this FPI, who is in the person who is investing money in India through FPI, who is behind this? What is wrong in this? Why they create fuss in the foreign investors?
You see, I think second question first, that the pattern of going away. You see, the no FPI is coming in India for the love of India. They are coming for the profit making. The sole purpose of putting money over here in the FPI space, not I'm talking the FDI, I'm not talking the FDI. FPI is coming solely for the purpose of the profit making. If our markets are performing better than the other emerging markets, whatever you do, they are going to put the money over here. They may threaten, they may show something, but ultimately they have to come because they are not in the charity business. They're in the business of creating the profit. So I have seen again and again this thing. They threaten when we stop the partition note, they threaten, came back. See, because ultimately the investors of there, they are not, they're the fund managers. Their investor asks for the return and they have to show the performance. So this is, I don't believe that is a big issue. But my concern was of the ease of doing business. But when we are saying the ease of doing business, that we should be constant, constant endeavor should be that we ease the process. I don't say you don't go for this thing, but I'm saying, but the impression should not go that we are making the thing harder for the people who want to invest in India. And certainly, which you raised the issue that Indian investors also not putting the money. Earlier, there was a concern that with our institutional investors, with domestic investors, were not much participating in the market. Except LIC, there was no other institutional investor was there. Retail money was scarce for that thing. So they have a disproportionate impact on the Indian market. Now, because our institution also matured, our banking system is also putting the money into the system for I think liquidity is sufficient in the system, so that the impact which they're having or influence they're having the market is get reduced to some extent. But I will not say it is gone completely, but their influence is not that much now. So that is the another part, and so we should not worry about the threatening per se. And if they threaten also, they're not going to execute the threat. It may temporarily halt otherwise, and then we can afford also this scenario that if they want to go away, let them go away. Now they're again coming, na? When at the time of COVID they sold the money at 7,500 Nifty, and now they're buying at 80,000 Nifty. Because see, return is required. Money is money. See, money is no color. Money is no color. Money is no color. Money is money. So I don't believe that is going to impact. But my concern was that only that. We should be very clear in our provision. We should be remain consistent into that, and it should not that habitual manner we come. That suddenly we say, okay, no, rules are changed overnight, and then because all stakeholders need to be taken into confidence and consultation to be done with all the stakeholders, and wider consultation to take place, so that the acceptability. Because I have learned one thing in my tenure in SEBI, that it is not challenge, not the making the best regulation. The challenge that how we can make them acceptable. And acceptability can be there when you discuss with all the stakeholders. And various stakeholders will have a very different kind of expectation, and you have to manage the conflict also in that scenario. So that has to be approached. That's otherwise paper is good for that matter, and certainly shadow of that immediate what is happening that is there in this paper, but it's a right step because the MPS I also believe. It's not a question of MPS, it's a question of transparency and the trust. That how the holding in a company is there. It will be less than 75 also. Na? You see, even the promoter has 50% only, but 20% is holding through the FPI. That also they not proper. Na? He is not breaching after that also the MPS. But that is not correct. The transparency is not coming over there. So that's my point. Thank you.
Okay, Ravi, there's a few questions have come. Are you aware of any precedents where the presumption was that the person charged is guilty until proven otherwise? This question,
several laws. I mean, the question is in context of securities law.
yes, maybe
Larger.
larger question, but we can confine to the securities law.
Yes, definitely. You see, Kanhaiya Baldev Bhai Patel was a case of front running in which there was no clinching evidence, but the proximity of calls and placement of orders were used as an evidence And then they could not discharge that presumption. And therefore, the matter traveled to the Supreme Court, but ultimately the guilt was established. And there are plethora of laws in India in which the burden of proof is reversed. But unfortunately, in SEBI Act, that burden is not reversed. It still operates on the cardinal principle, which Mr. Bindlish as well as Sir also pointed out, that you are innocent until proven guilty. And that's what this USTA paper tries to reverse.
Sir, Bindlish sir, in your career, when you have done investigation, when you have done adjudication, have you found this type of case? I'm just repeating, are you aware of any precedents where the presumption was that the person charged is guilty until proven otherwise?
Maybe at the investigation level, but not beyond that. When it comes to the quasi-judicial proceeding, then that may not sustain.
Okay.
It may investigation level, it may be at times, maybe that, but not beyond that. I have not virtually come across that thing. Generally, we used to filter out when it comes to quasi-judicial proceedings. Myself has, I think, exonerated a number of people while passing the orders. And that's why none of our orders have been overturned by SAT, and even Supreme Court also has upheld my orders. None of the orders I haven't turned down by because all are very reasoned order, and where I don't find that enough evidence, I will not charge the person.
That's good. That's good. Okay. Ravi, an investor communicates daily through mobile with his friends who is in CEO of listed company, but they do not talk anything about the company. Investor frequently trades in shares of the company in which his friend is CEO, which CEO is not aware. Due to some big announcement by the company, investor earns extraordinary returns. How can investor save himself if he gets notice of SEBI under his proposed regulations? You are afraid you are talking.
First of all, this investor will have to go through the Agni Pariksha. The one thing is sure that he'll be put to Agni Pariksha, and the circumstances may appear very suspicious from the chain of events, but it could be entirely benign also. In fact, the crux lies in what kind of scientific investigative methodology is applied. And for those who have to defend it, they have to come up clean and show the other dimensions to the regulator, probably which are being overlooked, clouded by suspicion. So, I mean, I have defended myself. I'm not disclosing the name. I've defended such an entity where two close friends were talking and there was an announcement. The person made profits and an ex parte order was passed, but the order was later on modified. So these are very common in securities market. But yes, if you have such connections, you be aware before trading in the script, because you will surely be put to Agni Pariksha.
Okay, Ravi. Now, I'm the investor who is investing regularly, but I'm talking to the CEO and my talk is not recorded. My number is recorded. Call recording is there. So how can anybody can defend that I was not talking about the company performance and other things? So how will you defend? You are doing trading, no doubt. Only thing is, if you are doing trading only in this script, then you are gone.
Yes.
But if you are doing trading, that is your defense. That you are doing trading in multiple script, and this is one of the script.
Yes.
Other script is only 10%. This is 70%. Then you have gone. Okay. Because
yes.
But if I'm equal, even then, how I can save myself by this? Because I don't have talked the conversation.
One of the crucial aspect of SEBI's investigation, which is on the which is these days, I've never seen such excitement and such movement in SEBI as I see these days, is testimonial investigations, wherein you summon, you record statements. So in this case, probably if the CEO as well as this person both are summoned and their statements are recorded, and if they're from their statements, nothing incriminating or contradictory comes out, probably that can be the best defense. Because in these cases, if you lie, if you lie or SEBI finds out some scienter from your statements, then you can be brought under the books.
But this is a difficult case to prove if everything is normal. Sir,
Yes.
you have any point of view? If I'm coming as a you are defending me for this trading.
No, see, to start with, the starting point will be you're guilty. The starting point will be that because the circumstances indicate that thing, right? And prudence probability will say that now you have to put a good defense for that. You see, what happens during the statement recording, people buckle down. And when the two people are called separately on the same day, we have seen the inconsistency in the statements also. And there they got caught. Otherwise, purely on this basis, if the statements also matches this and that, it will become difficult to charge the person. But I think the people should also be a bit careful that where you have the proximity with the management, you should avoid, this is the normal code of conduct of the market, that you should avoid those kind of companies where you have got a proximity. Because why to give a cause? The Caesar, why should be about suspicion? Why you are doing in this? Because whatever it may be, you say, I don't talk about the information. But all information is not required. From the body language, you can make out how the company is making. You see, communication is not required.
Okay.
And you see, daily basis, you know how he's behaving, how he's living. You can make out everything, how the company is doing.
Okay.
So,
now, another question. An investor comes to know from market that company A is considering some big positive announcement. Now, he's not a friend, he's an investor, but does not have any specific details about the transaction. Knowing this, investor buys big quantity, which is unusual pattern in his trade history. Regularly, I'm buying 5,000 or 1 lakh rupee shares, but that day I have purchased 50 lakh rupee shares in this system. Knowing this, investor buys big quantity, which is unusual pattern in his trade history. 2 days after his trade, company announced mega restructuring and price shoots up big time. Investor sells all his holding and gains abnormal return. How can investor save himself from proposed regulation?
First of all, your statement is that he don't have the information. He got a market big information. And these are the rumors, these are not the information. See, for that, the information has to be there. And when the investigation takes place, the details are seen. That when the information is generated. You see, media daily, day out in the morning, start in the morning, 7 o'clock, and they are dishing out all kind of information and people are working on that. So I don't believe that is the sufficient cause if you got no relationship with the company. There are so many incidents are there of that nature. You see, there is a saying in the market, I don't know what is happening in this company, but I know the person who knows what is happening in the company and I follow him. See, because it used to happen in this, this open article system was there now. You can make out because there is a jobber used to be there. He's a Reliance jobber. You can make out from the face of that person how he's placing the order that whether stock is going to up or down.
Sir, you have seen in the newspaper, like all big 5 newspaper, they come out, they gave some information that this company is doing this company is buying this. And after when it is happening, they are giving the same article with this. We have announced that 10 days back. So in the process, the newspaper person has purchased shares. What will happen to that? It is
the newspaper person has purchased the share after that information got published in the paper. Then it is a generally available information.
Yes.
Then I think there is no issue. Before he had done, then something is there into that. But I'm worried about another paper, or I think the regulation is already made or is going to be made. That rumor verification. I'm going to say the worst thing is going to happen for the corporate India. That you have to, whatever in the main media or the other media is in something that is coming to either deny or confirm that thing or comment on that. This is going to be a worst thing for the corporate India.
But sir, this will be a very big problem. It means that every day this is happening. So you are buying. So how the SEBI will, whether SEBI has this infrastructure, SEBI can do this, SEBI can identify this. It is a big burden.
No, it is not the question of that SEBI one this and that. For any corporate to deny or accept a rumor is a big challenge. You see, you deny or say, okay, then what is happening? No comments.
Okay.
They have no comments. That has got no meaning. You see, if I today some rumor is there that some acquisition taken, I'm acquiring some company. Okay. Now, if I accept that thing in the some journalist give this information that talks are going on from sources I came to know this and that. If I confirm that yes, we are talking, it's not that deal is done. I'm talking to that company for acquisition. To a computer may also come. We may come to know that this company is for sale. We also bid for that. You see, some confidentiality in the corporate system has to be maintained for activities. Everything, I always maintain this thing, transparency and nakedness are two different things. We should go for transparency, not for nakedness.
Okay.
We have to give some space.
Okay. Ravi, as per the case mentioned by SEBI, there's 5 cases they have mentioned. It is illegal to trade in OFS, QIP, preferential, and settling these SLB from shares acquired in OFS, QIP, and preferential.
No, not per se. Only if the activity entails a unusual trading pattern and is in proximity of an MNPI. That's what they wanted to showcase. Otherwise, general dealing, ordinary dealing is not illegitimate.
There's a Vinlisher, why, Nikita, for you also, why so much distrust on investors? It is FPI also, normal investor point of view. So, how far information provided is correct, reliable? More information leads more confusion, needs more reconciliation of information provided by corporates. So this is, somebody is giving comments that what is a call on this?
Nikita, you just
Regarding the disclosure, that we have seen that in many of the regulation there have been repetitive disclosures. One of the very now the SAST and PIT disclosures have been automated, but earlier there was overlapping in the SAST and PIT regulation also. So this is just one example. So there is a need to concise the information which should be there, but the so that investor can actually see through directly the information which is relevant for their investment.
Okay.
And if there is any foul play or anything, so there should be a mechanism to weed out any repetitive, any information which is overlapping with the disclosure which are already there in the other laws or in the public domain.
Okay. So now time is we are crossing.
Now, I will just make one remark that the information which is being sought and we are making DDP responsible for that.
Yeah.
Registration, DDP, now all granular will be maintained by the DDP, he will get all the information. Somewhere we say that he need to independently verify himself also that information is correct or not. Somehow I got uncomfortable with this kind of scenario. DDP are the commercial entities and are competing for the same set of the investors. To having this kind of the granular information, the DDP, I have got my own reservation for that. See, DDP is nothing. They are the depository participant. They are not a depository. They are the commercial entity. Generally, we have made the banks, we have made the DDP. With the banks also, and their custodian, but not banks, custodian and depository party made the DDP. But they're not sacrosanct. I have seen them. So having too much information with them is not a desirable situation in my view. Thank you.
So thank you very much, all. As we have a process, we have a system that we are asking the last comment relating to these things on the overall topic. So I'll start with Lisa from you. That what is your take on this and what is your advice?
On what?
On the both the topics which we have discussed.
All the topics. You see, these are the cause and objective is laudable for the papers having brought in. But it may not shoot in the wrong direction. It may not happen that it is shooting in the wrong direction. Especially this what is the regulation of this one unexplained species. I have got more reservation about that. that we should find out a way that how we can balance the both things. That because ultimately what is happening, because my concern is that the market, a lot of information flowing in the market, and trading takes place on the basis of information. Whatever you may say, either taking place through the algos or through the information, or algo also take into account the information only, what are the information available. So that is genuine information, authentic information, non-authentic information you have. And you will always see when some development has to take place in any company, you will find the volume will shoot up in that period. When the result is to come, you will find the volume will shoot up. So in that, to find out these things is very, very difficult, and we should not put too much onus on the investor. Let us trust. My belief is always that you trust and verify. Don't have the approach of distrust and crucify. First, trust people. I'm telling you, people are here to deal in the market to make the money over here, and not for with illicit mean everybody. Very few people who want to make the money illicit mean. So let them function properly, and we have got enough provisions are already there. We can tweak somewhere here and there for that thing to bring this regulation for it is like जैसे वो बोलते हैं ना अपना पुलिस वाला trigger happy. So we shouldn't become regulation happy. Just for anything we make a regulation. We should give more thought, in my view, on those issues.
Okay. Okay, Nikita.
I think other than FPI, I have already discussed in detail. Regarding the USTA paper, one more concern I was thinking about, that recently SAT and courts have dropped the proceedings since SEBI takes too much time. When SEBI has taken too much time in investigation due to of the delay, they drop the proceedings. And when now owners, they are shifting to the investors, I think that would be a really challenge in the cases where the case is very old, the records are not available with the person, there are change in the corporate structure. So yeah.
Ravi, your point.
So, sir, I have 2 points to make. I'll take 2 minutes. 1 minute on a topic which I left out while I was speaking on USTA. There is this regulation 4 in this consultative paper, and that's absolutely draconian, I must say. It says that it shall be the duty of every stock exchange recognized by the board and every intermediary registered with the board to immediately inform the board of any suspicious trading activity that has been noticed by them or brought to their notice in the course of their business. Mr. Bindish just embarked on this issue. I mean, these are commercial competing entities. You can't expect them to have the same kind of teeth and powers with you as you have. You have surveillance system, you can't do anything about them. You want intermediaries like merchant bankers, stockbrokers, all sort of intermediaries to report to you about suspicious trading activities. I mean, that's something which is incongruous so far as the realities of the world is concerned. Now, the next thing is, let us take an example. If securities market is SEBI's baby, my advice to SEBI is this: please give your baby a nice bath, clean it up, but then don't throw your baby out with the bathwater. That's my advice. You have to strike a balance. It has to be consistent, uniform. You can't look at it from a single dimension that, oh, this is horrendous. We have to curb fraud from the market entirely. No. And in the process to achieve that, you adopt all sort of means. So in our system, the jurisprudence says that it is not all about the ends. It's also about the means. So therefore, please give your baby a nice bath, but don't throw the baby out along with the bath water. That's my 2 cents on the matter, sir.
Okay. So thank you very much. Thank you all my learned speakers for giving the in-depth analysis of this law and the concept of this particular FPI, why it has come. And I'm grateful that today we have a company of Mr. Bindilesh who is knowing this, and I always admire his knowledge on the subject, not on the law point, but on the concept of why. So the concept of why this particular thing is, this is very, very useful. And I can't forget when he brought out this concept of the reverse book building process and one more concept which he has developed. It was coming in SEBI, but related to IPO market, which has not come. So that shows that he has a depth knowledge, and his knowledge of economics, knowledge of market, knowledge of subject and the financial, it's giving new impetus to his understanding of subject and providing to the market. So thank you very much. Thank you, Ravi. Thank you, Nikita.
Thank you.
Professor. And this,
Thank you so much, sir.
Thank you.
so friends, the journey of this knowledge sharing will continue. As you have seen that today we have completed 131st webinar, and previously we were thinking that we will start during only for the COVID period, but then we decided to share, because this is a CSR from our side to the society, to the professional at large, to the corporate at large. So this journey will continue, and the next Friday on 16th June, we are having our next webinar on right issue. Now, this is not the right issue only, the right issues, options available, and the modalities involved. So now in the right issue also, you have seen multiple type of instruments are coming in the right issue. So it is not a vanilla right issue. You can come out with so many different things added to that instrument and give a flying colors to that normal vanilla process to a new things. So we will discuss all these things, law of right issue, new process, new things, new instrument with this. So see you, and we'll meet on next Friday, 16th June at 4 o'clock with the new topic, this right issue topic. Thank you very much.